first speaker is going to address termination of relationships and litigation in the international setting. And the speaker is Mr. Robert Kosman. Robert Kosman is a partner in the law firm of Fasken Campbell Godfrey and its associated international firm Fasken Martineau. He has appeared as litigation counsel in all Ontario courts, the Federal Trial and Appeal Divisions, and the Supreme Court of Canada. He is Canadian chairman of the International Litigation Committee of the International Bar Association and a member of the private court as a specialist on international disputes. Mr. Kosman is counsel to the international section of the Arbitrators Institute of Canada and practices as counsel in international arbitration in addition to litigation matters. At the University of Toronto and Osgoode Hall law faculties, he has participated in advocacy in international arbitration lectures, seminars, and demonstrations. Would you please join me in welcoming Mr. Robert Kosman?
Thank you very much. The subject that I'm addressing today, termination of contractual relationships and litigation in an international setting, is a pretty broad subject, as you well know, broad enough to cover a large part of the practice of litigators such as myself, who's looking at business agreements, usually after a dispute has arisen where one of the parties is seeking to terminate the agreement. I cannot, in my oral presentation, obviously cover all aspects of such a topic, but I am leaving you with a 96-page paper with 120 references. So hopefully that will enable you to find key statutes, key cases, and more learned articles than mine when you need to do so. In my oral presentation, I wish to focus on one of the developing tools, and I say developing because it's a development in Canada and not in most of the world, that is the law of international arbitration as a tool of dispute resolution. It's a tool that business, particularly businessmen doing international work, are turning to more and more often, where they do not wish to have the disadvantage of being a party in somebody else's courts in another country. Although European, American, Mid-Eastern, and Asian countries have a long tradition of resolving international business disputes by arbitration, Canadian business has not utilized arbitration to any great extent until very recently, and there were very good reasons for that. Because until recently, firstly, Canadian arbitration statutes were based on a late 19th century UK statute which did not support the arbitration process, with the result that when you went to arbitration, you eventually ended up going to court as well. And I'm going to come to how that has changed under the present statutory regime. Secondly, until recently, Canada was not a party to the 1958 New York Convention on the Reciprocal Enforcement of Arbitral Awards, making enforcement difficult of arbitration awards that one might achieve. The rest of the trading world was, by the way, parties to that convention, and we shared the honors with Swaziland as not having joined that club. Thirdly, Canadian judges, again until recently, the last few years, were very jealous of their jurisdiction, believing that the justice that they dispensed was of a higher quality than arbitral justice. And as a result, and because of this attitude, arbitral awards were easily and often set aside in the courts. Just to give you examples of that, when I started practice, I had 2 cases in the Ontario courts where under the then Arbitration Act of Ontario, I was successful in having an arbitral award set aside on the ground that the arbitrator had misconducted himself. Now, one would think that that is a term which would go to misconduct such as accepting a bribe or acting inappropriately in some fashion. But there was Ontario jurisprudence that I could rely upon and did, which suggested that where an arbitrator had made an error of law or fact on the face of the award, a judge could intervene and set aside the award on the basis that the arbitrator, quote, had misconducted himself. I think that was stretching it. It is no longer acceptable, but it gives you an idea of the jealous jurisdiction of the courts up until recently. A second example that I will point to as to why it wasn't a very useful tool until recently was a case I had approximately 10 years ago, which was on appeal in Ottawa from the BC Court of Appeal. This is a case in BC which involved a commercial contract between a company in British Columbia and a company in the UK. There was an arbitration clause. The parties went to arbitration. The BC company was successful after a lengthy arbitration in Vancouver. The unsuccessful party moved before the BC Superior Court, had the award set aside. After another period of time, it went to the BC Court of Appeal, which restored the award. And 10 years from the date that the parties resorted to the expedition of speedy arbitration, I was in the Supreme Court of Canada giving it another shot. So I can tell you that in that context, and in fact my instructing counsel in that context told me that that was the last time that he would ever use the arbitration process. And if the statutory regime in Canada had not changed, I would strongly agree with him. Because this wouldn't happen today. Now, since 1986 across Canada, there is in all of the province international arbitration legislation that has been enacted that is strongly supportive of the arbitration process, and you'll see the various statutory references in my paper. In Ontario, you have the International Commercial Arbitration Act, which is, again, very helpful to enhance and support arbitration as a process in dealing with international commercial disputes. Just to point out some of the important differences from the new regime and the old regime. Firstly, under the new regime, under the International Commercial Arbitration Statute that is in effect in Ontario today, there is a provision for a mandatory stay of any legal proceedings involving a contract where the parties have agreed to submit their dispute to arbitration. It used to be discretionary for a court to grant a stay or not. In fact, the language of the statute was that the court may stay litigation if there was a submission to arbitration, and that always led to to cases where the courts had to decide whether or not the dispute was best heard by a court or by a board of arbitration. It's no longer discretionary. There's a mandatory stay imposed upon a court which you can resort to if there is an arbitration clause in an international commercial agreement. You go to the court. If someone has started an action, you ask you put before the court evidence of the agreement and the clause, and that is it. This judge does not have the discretion. I'll come back to that in a few minutes. Secondly, the legislation which is now in place implements the 1985 UNCITRAL model law on international arbitration. The UNCITRAL international model law was a United Nations compromise that was negotiated by representatives of countries from the East, the West, Asia, to try to come to terms with a set of rules and principles that would govern an arbitration process where there are different legal systems in place. So you had civil law jurists as well as common law jurists negotiating with respect to that UNCITRAL model law. In Canada and in Ontario, that model law is Schedule A to the International Commercial Arbitration Act. So our act that applies when you're dealing with an international commercial arbitration contract incorporates the provisions of the UNCITRAL model law. And under that Untitled model law, it's no longer open-ended as before. No longer will an arbitration be a first step in a long court process. Importantly, if an arbitrator makes an error of law on the face of the award, then, or on the face of the record, whatever the correct interpretation of the contract is, if the parties have agreed that that should be submitted to arbitration, the courts will not intervene unless the error goes to jurisdiction. And what is defined in that sense is carefully set out in the model law. And there is a case in the BC Court of Appeal called the Quintet Cole case, which affirms this and which is supportive again of the arbitration process. Another significant change is that Canada has become a signatory to the 1958 New York Convention on Reciprocal Enforcement of Arbitral Awards. Today, as a result, the enforcement of an arbitration award is easy, often in fact easier than the enforcement of court judgments in other jurisdictions. If you have reference to the model law, Article 35, which sets out what the convention requirement is, provides as follows. An arbitral award, irrespective of the country in which it was made, shall be recognized as binding and upon application in writing to the competent court shall be enforced subject to the provisions of this article and of Article 36. So the Untitled model law requirement for enforcement, which speaks to the requirements of the 1958 New York Convention, is incorporated in our law today, with the result that you can take an Ontario award, if the party is a foreign party, you can go to a court, a competent court in that jurisdiction, and you can have your award enforced without going through a litigation process in the other jurisdiction, and I've done it. I had an award several years ago now, but since the Act's enactment, for several million dollars Canadian against a company in Scandinavia. Section 35 that I read to you in subsection 2 requires you to get that award translated and authenticated, which I did, although I had some difficulty with the authentication. To get it authenticated, you had to bring it to the consular office in Toronto for the country in question. When I did so, it was refused initially because the experience of that office was only to deal with awards where the Scandinavian company had been successful. A call to Ottawa resolved that problem, and they authenticated it. I then put it in the hands of local counsel in the Scandinavian country in question, and they put it within days in the hands of what was a sheriff in that country. And we got a payment on that award through the enforcement mechanism in the legislation, without having to go through litigation or any difficulty in the foreign jurisdiction. Now that is accepted, and that is accepted practice. Not so much in Canada or US, where most people wouldn't even be familiar with it, but it's accepted practice in European nations. That's just the way things are. Arbitration awards are something they deal with regularly in their course of business, and enforcement of the award is something that is done. So when you come to the issue of litigation against arbitration with respect to international disputes, the litigation issues are relatively straightforward, and they're often canvassed under the headings of, well, what forum will I be litigating in, and what is the proper law of the contract, whether that's express or not within the agreement in question. But and that, by the way, is covered quite extensively in my paper. But why employ an arbitration clause when you're dealing with an international commercial contract? And if so consulted, why would you recommend it? There are a number of good reasons for that, and I want to just go through them based upon my own experience and just generally the general state of knowledge on the subject. Well, one of the obvious reasons for resorting to arbitration is that it keeps the dispute private. So if you're dealing with business that doesn't want like the McCains, to have their business dispute splash all over the front pages of the newspapers. An arbitration will keep the dispute out of the public eye. In fact, as you know, arbitration was eventually settled upon as the way to resolve the McCain dispute, notwithstanding the initial publicity of the public litigation. So it keeps it private, which for some business is a very important virtue. Secondly, it keeps it out of the courts of other countries or states. And I say states because you may be happy defending an action in Ontario on behalf of a client or another Canadian jurisdiction, but you may not be so happy as a client facing litigation in Texas or Turkey, with apologies to anybody I've insulted in the room. So one of the issues with respect to keeping it out of the courts of other countries is that some countries aren't very friendly to persons outside of their jurisdiction, or at least there's a perceived bias on the part of your client that they won't be treated as fairly within the jurisdiction of the other country. Thirdly, as contrasted with court resolution or dispute resolution through the litigation system in the courts, today, in my view, there is greater certainty in the arbitral process, contrary to the conventional wisdom, than there is in the litigation process. And this is especially so especially so in dealing with American states or American jurisdictions where commercial disputes are still subject to jury resolution. If you, as you all know, a commercial dispute here is unlikely, or hardly ever gets to a jury, but that still is common in the U.S. So one of the juries are notoriously unpredictable, and so one of the issues for you, where a U.S. party is on the other side of the contract with your client, is do you want to be in that American jurisdiction? What will be the result of this litigation? So unlike the arbitration process, where people used to say, well, an arbitrator will just saw the baby in half, a jury may even go further, and you may be quite unhappy with the result. Fourthly, if you find yourself, assuming you're acting for a Canadian party or a Canadian company or advising a Canadian company, before an American court, if your client finds itself before an American court, your client will find itself subject to onerous discovery processes. As you know, unlike our system where you examine a representative of the opposite party, under most American jurisdictions, if it moves, you depose it. And you depose all witnesses and not just simply a representative of the opposite party. So that as a result, both from a business perspective and from a cost perspective, litigation can be an onerous process. And fifthly, and in my view most importantly, through the international arbitration process, not only are you spared the uncertainties of litigation in another jurisdiction, you're also spared the uncertainties of who is going to decide your case. One of the greatest, and in my view the most important advantages of arbitration is that you select your judge. And I say judge because if your case involves serious legal issues, you choose a judge or a retired judge or a senior commercial solicitor or a barrister, and that person is often in a better position to decide the dispute than the hit or miss of, with great respect, the Ontario Court General Division, where somebody may have done nothing but practice family law or municipal law before being called upon to decide a contractual dispute in the Ontario courts involving a lot of money and an important commercial issue. We do have now, as you know, the commercial court, which to a certain extent relieves against that problem, but there's still a lot of unhappiness with that among the litigation bar. Just to give you an example, well, this morning I'm on an examination on a dispute between an English company and a BC company over a business enterprise in Ontario, and we have selected the Honourable Dick Holland, formerly of the Ontario Court or the High Court, as our arbitrator. So we have the experience of a judge who is well known and well respected, and who has lots of experience in cases such as Lac Minerals. So effectively, we have selected a commercial judge of our choice to hear the case. I had a dispute between a Danish company and a Canadian company, where the Danish company was a subsidiary of ITT out of the U.S. and had Washington counsel. I was representing the Canadian company. Neither side wanted either an American or Canadian arbitrator. The decision was made to go to England to get someone from a common law tradition, and we chose one of the sort of leading commercial silks in London, who is very experienced as an arbitrator of a large hardware and software contractual dispute. So we chose somebody who was experienced, somebody who wasn't in the jurisdiction of the other, neither American nor Canadian, and yet someone who knew the international world of business, was an accomplished litigator in the commercial area, and who, I must say, gave a very good award. Sixthly, with respect to international arbitration, it can be faster. In the U.S. experience, I point out if your client is contracting with a U.S. party and therefore may find itself in a U.S. court, in New York, you may wait 10 years to get to trial if a dispute does arise. As well, you have the problem and difficulties of the deposition process to go through, in addition to the expense that's added onto that. In Ontario, it's become a lot better. It's a lot quicker to get to the courts, but at the same time, by using the arbitration process and selecting a good arbitrator, such as Dick Holland, for example, you can get a matter on very quickly. With respect to the matter that I'm examining on this morning, Justice Holland, the Honourable Mr. Holland, we approached him in the summer. He set a schedule in place with the arbitration to take place in November. And so we're in the discovery process right now, a limited discovery process on that case. So from start to end of the dispute, it will be under 9 months. In fact, it may be under 6 months. Seventhly, the arbitration process is not necessarily less expensive, but the time saving and the limited pretrial procedure, pretrial procedures that are available may make it so. However, one of the things, of course, that you have to deal with is that you have to share the costs of the arbitration, or the cost of the arbitrator, and in court, at least at the moment, on a commercial dispute, you don't have to pay for court time. Both the judge and the courthouse comes free, although there's talk of changing that with respect to certain kinds of commercial disputes. With respect to time and money and the expense of arbitration, I would strongly urge, based on my experience, the selection of one rather than 3 arbitrators. Both cost and logistics favors having one very good arbitrator respected by both sides than having 3. It is just terribly difficult to get all 3 together, at the same time, and over and above that, you're paying the not inconsiderable fees of three people. So assuming you are interested, or your client is interested, well then what kind of clause should you use in an international commercial agreement? What rules should you apply? Well, there are basically 2 different kinds of international clauses. Or international agreements to arbitrate. You have, firstly, the ad hoc agreement. The agreement that must be entered into or negotiated between the parties when a dispute arises when it's not contained in the international commercial agreement to begin with. Or alternatively, it's in the agreement, but it doesn't specify any particular rule regime to follow. So you often, with an ad hoc arbitration, you ought to have in your arsenal a good draft clause which addresses many of the kinds of issues that do come up. One of the commercial solicitors in my office has spent some time in that, and it's one that is available to the commercial solicitors in the office who want a model arbitration clause for to go into an agreement. The alternative is you incorporate by reference a specific arbitral regime. The International Chamber of Commerce, based out of Paris, the London Court of International Arbitration, based out of London, the Arbitrators and Mediation Institute of Canada, which is a Toronto-based organization, or the American Arbitration Association. All of these have clauses and rules, and you can incorporate those rules by reference by indicating that the parties agree to submit their dispute to arbitration in accordance with the rules of the International Chambers of Commerce. You also can import their legal costs, the legal costs of these regimes, and that's one of the things you should be aware of. The ICC in Paris, from my experience, is very, very expensive. In one case that I had, because of the size of the amount of money in dispute, they wanted a $50,000 US upfront administrative deposit, a non-refundable, which would pay for the costs of the administration of the process. Faced with that, because there was an ICC clause in the agreement to start with, you're not necessarily stuck. If both parties want, you can contract out of that clause. Merely because you find yourself with somebody else's arbitration clause providing for an ICC arbitration, you can negotiate with the other side or another party to replace the ICC agreement with another arbitral clause. And I've done that where I've basically got together with a lawyer on the other side, said, look, we can go this route if you want. In fact, we're required to unless we both agree. But I would suggest that we use another regime which is less expensive from an administrative perspective. And so we negotiated an ad hoc clause in that case, which the parties agreed would substitute for the clause in their agreement. And that clause, of course, is similarly binding.
Robert, can I ask you to just make your conclusions, please? All right.
There are a number of other factors that I would like to bring to your attention, but given the time, I'm sorry I just don't have the time to do that. But again, I would refer you to the paper which deals with a lot of these issues, and I would certainly be glad to answer any questions after the session is over, given the time constraints that we're under today. I can also tell you, just perhaps in closing, that the statements that I referred to in the earlier decisions, whereby courts, because of the jealousy towards their jurisdiction, interfered with arbitral awards, is no longer the case, and there is any amount of statements by judges in recent decisions which show an increased understanding of the role that arbitration plays in international contract making. In my view now, at this time, it is open to use those clauses in a way that you couldn't do so in the past, and it's an effective form of dispute resolution. Thank you.
Thank you very much, Robert. If there are any questions, we can take a couple of minutes now and deal with those. Yes, please.
We were involved with an arbitration, and we didn't have the success that you seem to have. We were the losers. We were the defendants, and it was under the AAA rules. We received no written decision other than, you guys pay those guys X dollars. And I understand that
the AAA tradition is not to have written reasons. If you want written reasons and you have an American Arbitration Association clause, you should provide for it. I much prefer written reasons. Not only do you want to see how the arbitrator came to the decision that they made, or he made, or she made, you also want to impose upon the arbitrator the critical process that writing reasons requires. But it is clearly the tradition in the AAA, especially in arbitral cases where there is not an international arbitration clause, never to write reasons. And they have very much different tradition. Arbitrators in domestic cases are often volunteers. There are no fees, and they don't impose upon the arbitrator the requirement. And they also are of the view that it'll lead to fewer court battles if there are no reasons presented, and an award is made simply as a dollar amount going either way. In Europe and in the Canadian tradition in international arbitration, reasons are called for, are the tradition, and if there's any doubt, and it's been my practice, is to require them.
We also found that the lack of rules of procedure was very frustrating in terms of the evidence that was being presented by the other side. I mean, basically, it was their word against our word on many of the issues, because neither party had documentation. And I guess it was our view that the other side wasn't very honest, and because the rules are so non-existent, I mean, you know, the biggest liar ends up being the biggest winner at the end of the day. We found the experience very frustrating.
The absence of rules, in my view, doesn't assist conclusively with respect to determining issues of credibility. And I mean, as you know, those kinds of cases are won and lost in the courts every day because of the statements of people and where there are issues of credibility. But that goes to the importance of the rulemaking regime. I indicated that you can incorporate by reference different rule systems, and those different rule systems that are in place, and I strongly recommend the London Court of International Rules are as good as the Ontario Court rules and can lead to as good a result, in my view.
All right. Thank you very much, Robert. Our next speaker is Blake Murray, and he's going to talk to us about income tax considerations. Just read Mr. Murray's CV. Blake Murray joined Osler Hoskin in 1973 and has practiced as a tax lawyer with the firm since being called to the bar, the Ontario Bar, in 1975. Mr. Murray was admitted as a partner in 1981 and serves a diverse commercial group of clients. Professionally, amongst other commitments, Mr. Murray was the past chairman of the Commodity Tax Committee of the Canadian Bar Association, and from 1989 to 1990, he served as counsel to the House of Commons Standing Committee on Finance and Economic Affairs with respect to public hearings on the goods and services tax and the subsequent review of Bill C-62. He is currently a member of the Taxation Committee of the Toronto Board of Trade and the editorial board of International Tax Planning, published by Federated Press. So would you please join me in welcoming Mr. Blake Murray.
Thanks very much, Stephen. Now, can everyone hear me? This is going to be quite a trick here. Can I turn this on? I can say that I don't generally operate this myself. So. What do you think this is? All right. I've got a series of overheads here that I'm going to use to illustrate my talk and just take you through. So.
Nice piece of equipment, eh?
I'm not sure how well it's going to work.
So do you have your templates also in your paper? Or?
I will be handing out these overheads, but not today. I'm sorry. I think I overcommitted myself in the number of papers I'm doing. So I just have the overheads, and I'm going to try and arrange with the Law Society to get a set of them to the registrant. So you will have them, but you don't have them now in your materials. Anyway, I want to go through a series of points. 30 minutes to cover the international tax system is a little short. I mean, I'm not complaining, but I noticed the guy that serves coffee got 20 minutes, and I'm not going to be able to deal with any of these subjects in detail. So what I'm going to try to do today is give a framework within which you can operate. At least you'll have some questions you can ask whenever you're evaluating a transaction. And basically, I'm going to hit on the framework more so than detailed points or detailed planning tips. And so we'll start with the objectives of international tax planning as listed there. Minimize current Canadian and foreign tax, maximize your ability to repatriate earnings and capital at a minimum cost, minimize the Canadian and foreign taxes on disposition of all or part of the foreign assets, minimize the after-tax cost of financing your foreign operations, and minimize your foreign currency exposure. And foreign currency exposure actually is quite a big tax risk because apart from the exchange risk itself, you have to worry about whether you'll get relief from foreign exchange gains or losses as to who has the risks, because different tax systems work differently in terms of denying or allowing relief for exchange gains and losses, and they're very often not taken into account in investments. Now that on the framework side of things, whoa, Ron, it's slightly worse than the last overhead. The methods of doing business is it not? Infuriating. Sure, that's better or not. Methods of doing business is essentially two broad methods. There's a direct and the indirect, direct and indirect operations. And under direct operations, I'd include direct sale to a foreign purchaser, licensing a foreign manufacturer or distributor to produce and sell the product, establishing a foreign branch operation of a Canadian entity. And under indirect operations, there's essentially the use of a foreign subsidiary and or use of two or more foreign subsidiaries in conjunction with each other. So B is really a variant on A. I'm going to speak to these. Now, obviously, that's not exhaustive of the foreign ventures that you'll see. You can see foreign partnerships, joint venture arrangements. But in principle, I think they break down into those two categories of direct and indirect, and then these variants, and then they're put in combination with each other to produce different results. And for example, a Canadian company can have a foreign subsidiary and then license that foreign subsidiary to produce products. So you've really got a combination of licensing a foreign producer and the use of a foreign subsidiary. So I'm going to take you through these methods of doing business and make comments on the tax aspects of each of the methods. On direct sale to a foreign purchaser, I'm referring first to foreign income tax considerations. It's very important to establish whether you're dealing with a treaty or a non-treaty country, or to put it another way, whether or not treaty protection will be available, because you get a totally different tax result where you have a treaty. Very often the domestic tax laws are quite overreaching, and it's only through treaties that you'll get relief or protection from what the local tax result would otherwise be. If you don't have treaty protection, and I've established that as a non-treaty country, and that could be for a number of reasons. You could either not have a treaty, or there could be a treaty and you could fail to qualify for it. An example of that is very often in a treaty you have to be a resident of the contracting party. It wouldn't very often happen in the context of a taxable Canadian corporation, but by way of example, to be a resident you have to be taxable in the jurisdiction that is the contracting party. So if it should turn out that you established a branch in another country and then that branch operation was in turn doing business in a third country, it's possible that the branch operation would qualify for treaty protection. It's possible that it would not. You have to look at the treaty itself to see who's entitled to invoke the protection of the treaty. And you get different results under different treaties. And I've had that situation where, in some cases, some treaties, branch operations in third countries qualified for treaty protection. In other cases, they're denied that protection. It depends very much on the scope of the treaty. And as I said, if there is no treaty, then it's fairly straightforward. So if you're dealing with it on a direct basis with a non-treaty country, you have to refer to the local tax laws, which will vary. Just as a general test or watch-outs, should look to where property and the goods will pass. I mean, just as a general rule, it would be a good idea to have property or title to the goods pass outside of the country in which you're selling. And that's the case, for example, well, we have a treaty with the United States looks to where title passes. So if goods are being sold from a non-treaty country into the United States, title passes in the United States, they view that as being effectively connected with the United States and that they can tax it under normal rules. Title passes outside and there's no fixed place of business, then they'll view that as being outside of, not being of U.S. source. So you should look to where title passes, look to whatever activity you're carrying on in that country. Are contracts being made there? Will there be an office? Will you have salesmen? That may be sufficient under local law to bring you within the tax net. You have to consider your potential liability for capital taxes. Apart from income taxes, and usually as an extension of income taxes, you have to be concerned about whether you will have a local liability for capital taxes, for branch profits tax, and finally, whether you have a liability to withhold tax on amounts paid to employees that you may second. And for example, you may be selling goods on a direct basis, title passing FOB Canada to a purchaser in a third country, and let's say the United States, but you may then be seconding employees to the installation site for the purposes of installing the equipment. And so you have to be concerned about whether or not, apart from the income tax liability of the person carrying on business, one has to be concerned about whether you have a liability to withhold tax on salaries and wages paid to your employees in the foreign jurisdiction. I'm going to move to the treaty situation. Even better. When you're dealing with a treaty country, and the issues are, will a permanent establishment exist, which I said before, I guess the first issue is, does the treaty apply? But secondly, if the treaty does apply, the general test under a treaty is that business profits are taxed if they're attributable to a permanent establishment. So a threshold issue is, does a permanent establishment exist? General test for that is whether you have a fixed place of business, or, and then this is wrong on the overhead, first whether you have a fixed place of business, and secondly whether you have an agent other than an independent agent acting in the ordinary course of business with authority to contract. And it's basically you're looking to a fixed place of business, office, factory, sometimes warehouse, and or an agent or an employee with authority to contract, and they carve out independent agents. If you have such a permanent establishment, the general rule is the income that is allocable to that permanent establishment will be taxable in the foreign country. And that's another reason why you have to define what the permanent establishment is, because not all income that you earn will necessarily be allocable to the permanent establishment. For example, you could be selling to one party through a permanent establishment and selling to other parties outside of that permanent establishment. You could have interest receipts which would not be allocable to the permanent establishment if you were lending into the country as well as selling goods. So you have to determine what amount of income is allocable to the permanent establishment. And I guess the first part of that is really asking whether the income is connected with a permanent establishment. The second part is determining the calculation of income allocable to the permanent establishment, which will entail questions like whether you can deduct interest, whether if you're selling goods through a branch operation with a permanent establishment, whether or not you can effectively recognize a profit in Canada for the wholesale value of the goods and take the profit on the resale in the foreign country. Actually, I've got myself off on the wrong foot in the sense that if you're in a direct basis, normally you're trying to avoid a permanent establishment. So if you're selling direct, I'm going to deal with branch in a moment, and I've sort of mixed the two together. If you're selling on a direct basis, you'd be attempting not to have a permanent establishment, to sell in Canada and to avoid tax in the foreign jurisdiction. If you're selling in a branch, you've embraced the permanent establishment and you're living with the question of how much income is allocable to that permanent establishment. So I've sort of merged the two in this overhead. Finally, if you're dealing on a direct basis, you have to be concerned about Canadian tax considerations, and two considerations that jump out, or that it's almost hopeless. Two considerations that jump out is that any income that you earn will be taxed on an accrual basis in Canada. There'll be no deferral of Canadian income tax. Income, of course, will be calculated using Canadian rules. So you may well have no income in the foreign country, but depending on how they calculate depreciation or other amounts. But for Canadian purposes, you use Canadian rules to calculate your income, and your Canadian tax liability will depend on that. I'll have something to say about foreign tax credits in a moment. And the converse of that, and the upside, is that if you have losses, again computed under Canadian rules, you can take immediate relief in Canada for those losses. Now, one of the sort of things you have to think about is that if you establish a business on a direct basis, whether selling directly or establish a branch, you have to be concerned about what will happen when you attempt to move from that branch to a foreign subsidiary. And that's one of the reasons why people will, in some cases, start with the foreign subsidiary even though they may have startup losses. And the concern is that when you sell your assets into the foreign subsidiary, there will be no rollover. So you'll be triggering Canadian tax when you move from direct or branch to a foreign subsidiary. And what you're measuring is effectively the benefit of immediate relief on those tax losses that you may incur in the startup years against the tax cost of later incorporating that foreign subsidiary. And it'll depend on the facts as to whether or not the tax cost appears to be prohibitive. I mentioned that the existence of a foreign tax credit, and essentially the system is that if it is a business income tax, to be a business, there's basically a split between two kinds of foreign taxes that you can pay, a business income tax and a non-business income tax. To be a business income tax, you must be carrying on business in the foreign country under Canadian rules, which generally turns on the case of the sale of goods, where the contract was made, in the case of and where delivery was made, where payment was made. Those three are the main indicia. The other situation is in the case of a sale of services, and the test, generally speaking, is where were the services performed, which gave rise to the profit in substance. So you have to apply the Canadian rules to determine that whether you're carrying on business in the foreign jurisdiction. If you are, then you get a 7-year carry forward, and it's 3 years back of any unused foreign tax credits. If it's a non-business income tax, essentially that is a tax that you pay on income other than income from carrying on a business in a foreign jurisdiction, and there is no carry forward, which means that you have to be taxable in the year for Canadian purposes to effectively utilize the foreign tax credit. You can, however, elect to deduct that foreign tax, or the portion that's not creditable, instead of taking it as a credit. And just to say it, a credit is a dollar for dollar recovery of the tax. A deduction, effectively, if you've taxed at 40%, you get a $100 deduction, you get $40 back. So you would rather have a $100 credit than a $100 deduction. The basic formula for the foreign tax credit is that you take the foreign source income over your world income and multiply it times the federal tax otherwise payable. So you're always limited by the federal tax that's otherwise payable. And therefore, if the Canadian taxpayer is in a loss position, they will not be able to claim a foreign tax credit in the year of loss. And that then pushes you into the issue of whether or not you're dealing with a business income tax or a non-business income tax because of the inavailability of a carry forward on a non-business income tax. Just very quickly, as I mentioned, in the overheads that the portion that deals with branch really assumes that that you have got a permanent establishment in the foreign country. And again, the same questions have to be asked. Essentially, the issue is the amount of income that's attributable to a permanent establishment. If you have a treaty, if you have no treaty, then you have to ask whether the activity is sufficient to give rise to a tax liability. It almost invariably will if you have a permanent establishment in the foreign country. You have to be concerned about differences in the rate of taxes, such as apart from the basic tax rate, and also concerned about branch profit taxes. And you're probably familiar with this, that if you were dealing through a corporation, you would have earnings, and as those earnings are paid out as dividends, they would attract a withholding tax. The branch profits tax, which is levied in a number of countries, is essentially a proxy for the withholding tax on dividends out of after-tax earnings. And so generally speaking, a branch profits tax will operate on the basis that it'll be a calculation of your income less the local taxes that you've had to pay and less some form of investment allowance for the assets that you retain in the foreign jurisdiction. If you begin to repatriate funds by reducing your investment in the foreign jurisdiction, you'll trigger a branch profits tax. The rate of the branch profits tax quite often is set by reference to the rate of withholding tax on dividends. So if that rate happens to be 35%, in Canada's case it's 25%, then the basic rate of the branch profits tax will equal the general withholding tax rate on dividends. And then you then look to the treaty for a reduction of that rate to the dividend rate. And in the case of the Canada-U.S. treaty, the branch profits tax is reduced to 10%, which equates to the withholding tax on dividends. Again, you have to be concerned about capital taxes. Both, I've got it down as a foreign consideration, but you must also be concerned about capital tax in Canada, because the capital that you have in the foreign jurisdiction may count in your capital for federal capital tax and Ontario capital tax purposes. I'm going to move to licensing a manufacturer or distributor in a foreign country. So the threshold question is whether the licensing gives rise to a disposition of property. And what I mean by that is, generally speaking, one would not expect a true license to give rise to a disposition. But if you sell off all the rights for a country, effectively, if you grant a license in perpetuity to either to distribute software, or to say to produce and distribute software, or to produce and distribute a film, then in fact you may have done a disposition of the copyright or of a patent or whatever the underlying right is in that property. So you have to look in substance as to whether the purported license amounts to a disposition of the property. If it's not a disposition, then the next issue essentially is whether income tax or withholding taxes will apply to the payments that you receive under the license, and what is the applicable rate of withholding tax. And that takes you to what is the base as well. What's the rate of withholding tax and what is the base? The general rule on amounts that are subject to withholding tax is that the taxes are levied on the gross amount. But then the question is, what is the gross amount? And I've seen situations where the local distributor may be required to incur certain expenses, like co-op advertising or similar expenses. If the license is drafted properly, those expenses will be on the account of the local distributor and will not count in the base for the royalty. If it's improperly drafted, you may find that effectively you've got a contract where there's a gross royalty back to the licensor, out of which the licensor then has to absorb local advertising. The problem with that is that that expense of local advertising, generally speaking, will not be deductible in determining the base for calculating the withholding tax. So the licensor ends up paying a withholding tax on an amount he never receives. The treaty protection is very important in the case of licensing, particularly in the royalty situation, because the general rates can be quite high, 25, 35%. The Canada's treaty norm is at 10%. You may be able to do better than that depending on the where the licensing is occurring. as I've put down, consider the royalty formula. The other consideration, which is depends very much on what it is you're licensing, is considering a gross-up clause for withholding taxes. If you've seen computer software contracts with U.S. vendors, it's become pretty standard for them simply to ask to be grossed up for any withholding taxes. So effectively, they're ignoring the foreign tax credit and asking to be compensated for withholding taxes. If in fact they're able to get a foreign tax credit, then it's a bigger win for the licensor. But that clearly is going to depend upon your market position and whether you'll be able to negotiate for such a gross up. Similarly, on the Canadian tax side, there's a question of whether there'll be a disposition of property for Canadian tax purposes, and you'll have to be concerned about the timing of the inclusion of rents, royalties, and other amounts paid. Generally, they're included when paid with no reserve, so that if you have a big payment, big prepayment under a license, that'll go into income in the first year without any ability to amortize it over future years. On the other hand, if you stagger the payments, they'll come into income as paid. There's is a reserve for unearned amounts, for example, for service to be rendered or rent paid in advance, but no reserve for prepaid royalties. So it depends very much on the property that you're licensing. I've mentioned previously the operation of the foreign tax credit. I've got a number of overheads giving more detail on the foreign tax credit, but I think I'm going to spare you those and shift to, I think, to the indirect method of carrying on business. Okay, on the indirect point of indirect operations, effectively, you're talking about using a foreign affiliate. So you therefore are going to have to qualify the foreign subsidiary as a foreign affiliate. Just by way of overview, a foreign affiliate is going to be a corporation in which a Canadian taxpayer holds at least a 10%, at least 10% of an issued share, of an issued class of shares, and that's concept is relevant first with respect to the repatriation of dividends from foreign subsidiaries. Essentially, a foreign affiliate receives no foreign tax. A Canadian taxpayer, Canadian resident corporation with a foreign affiliate, doesn't fall under the foreign tax credit system when it receives dividends from that foreign affiliate. Instead of that, there's a special system for taking dividends, and effectively the retained earnings, if you like, of the foreign subsidiary are, for Canadian tax purposes, divided into three pots. There is exempt surplus, taxable surplus, and pre-acquisition surplus. Exempt surplus essentially is income from an active business in a listed country, and the listed countries pretty well equate with countries with whom we have treaties. Exempt surplus comes back tax-free. You include it in income, you deduct it in computing taxable income. Taxable surplus is income from an inactive business or income from a business not in a listed country, and the situation there is it's the amount of the dividend is grossed up by the foreign taxes, and you then get a calculated deduction, which is a grossed up deduction, which effectively puts you pretty well in the same position as if you got a full foreign tax credit for those foreign taxes. So you're still not an unfavorable position on taxable surplus, but not a tax-free treatment. So if the foreign taxes are clearly less than the Canadian taxes, you will have a additional tax to pay when you repatriate. So exempt surplus is best. Taxable surplus is a clear second. The third category is pre-acquisition surplus. Really refers to earnings that are attributable to a time before you acquired the foreign affiliate, before it was a foreign affiliate. and that essentially comes back as a reduction of your cost base. It's included in income deducted in computing taxable income, but reduces the cost base. And if you get a negative cost base, you trigger an immediate capital gain. So you can have a capital gain while you're holding a property if the cost base goes negative. In any event, if you reduce the cost base, it'll increase your capital gains exposure on the ultimate sale of that foreign affiliate. So essentially, if you're dealing in a foreign subsidiary, you're going to want it to be a foreign affiliate because you're going to want to access the ability to use this surplus system. The next concept I want to introduce is the controlled foreign affiliate, which is a foreign affiliate. First of all, it has to be a foreign affiliate, and secondly, it has to be either controlled by the taxpayer or by the taxpayer with 4 or fewer Canadian residents, or by the taxpayer in non-arm's length persons, or by non-arm's length persons. So it's basically a combination of possible situations which would create a controlled foreign affiliate. Shareholders or Canadian taxpayers with a controlled foreign affiliate are required to pay tax on an accrual basis on the foreign accrual property income, read passive income, of that controlled foreign affiliate. Now, certain items of income are not FAPI. And for example, if you have a foreign affiliate and it cross-charges another foreign affiliate, and the cross-charge is deductible in computing active business income of the payor, then that amount is deemed to be active business income to the payee. So you can have a series of foreign affiliates cross-charging each other, and even though on the face of it a rent or a royalty might appear to be a passive source of income, interest might appear to be a passive source of income, it'll be deemed to be active business income and go into the exempt surplus pot if the charge was deductible in computing active business income of the payor. Essentially, the FAPI is taxed on an accrual basis, so you pay the Canadian taxes when they come in. It's added into taxable surplus, and later on when you bring it back, it comes back tax-free through a series of rules. I guess the last thing I want to deal with is transfer pricing, and I just want to alert you to considerations of transfer pricing. In the Canadian, this material over here. Go. Canadian context, to be concerned about Section 69 of the Income Tax Act. There's an information circular published by Revenue Canada on transfer pricing, which is 87-2. The U.S. has recently published detailed regulations under Section 482 of the Internal Revenue Code on transfer pricing methodology. You also have to be concerned with advanced pricing agreements, which are is a buzzword now for pre-clearance of transfer pricing, particularly by the U.S. And Canada has agreed to consider a request for advanced pricing agreements. And there is the competent authority mechanism in the treaty system. If you have a treaty, then there's a mechanism in the treaty itself for adjusting pricing between related parties, and there's a competent authority mechanism for resolving disputes between 2 taxing jurisdictions. Just by way of example, if there's a Canadian parent and a U.S. subsidiary, and Canada believes that the Canadian company charged too little, that it may seek to increase the price or the income of the Canadian parent company. Now, if the U.S. subsidiary has calculated its income on the earlier lower price, it's already paid tax on the amount of that charge. So if there was no mechanism for getting a greater deduction in the U.S. subsidiary, there would be double tax. The Canadian company would pay tax on the reassessment. The U.S. company has already paid tax on that item of income. Essentially, the system is that you work with the tax authorities, the local tax authorities, and ask them for what's called a correlative adjustment, which is the corresponding adjustment. If they refuse to give the adjustment, there's a mechanism for appeal, which is essentially a form of arbitration in which you're not present, between the competent authority of the 2 treaty countries who will meet to resolve the difference. And essentially what they'll do is they seek information from each of the taxpayers, the Canadian taxpayer and the U.S. taxpayer. They sit down together and then they attempt to resolve it. And essentially what they're doing is they're attempting to resolve the tax split as to who, in fairness, should receive the taxes on the disputed item of income. And I'd say apparently Revenue Canada has indicated that 93% of the competent authority cases that we have are with the United States. They appear to have all been successfully resolved in the sense that they've reached a settlement of some sort. I won't say more about it, but it's basically, you know, if you're in a transfer pricing case, you're going to want to protect your ability to get competent authority protection because ultimately it will eliminate the double taxation. It may take a long time. It's a very lengthy process, but eventually the probability is that if you're dealing with the United States, at least, that there'll be a resolution and the item will not be taxed twice. I do want to just say a little bit more, though, about the other sort of current issues are the addition to provisions in both the Canadian and U.S. tax statutes dealing with access to information. There are exchange information articles in the treaties. In addition, there's statutory provision in the Canadian Income Tax Act to require a taxpayer to provide information with respect to foreign operations. And it seems that we're living in a world where there'll be increased availability of information with respect to foreign operations, and that's certainly a consideration in terms of structuring and just making sure that that the planning is on a sound foundation. That's I guess that's all the time there is. So thank you very much.
Thank you very much, Blake. We have a minute or two for questions if anybody would like to ask a question of Mr. Murray. If not, we move at this point to have a short break, say for 7 or 8 minutes as opposed to 15, so we can try and keep things on schedule. So why don't we agree to meet back at I have 2:30 at 2:35.